I don't need an estate plan because my estate is small. So, truth, the size of your estate doesn't matter. Having an estate plan is critical regardless of the size of your estate because it ensures that your assets are distributed according to your wishes, and it ensures that you're in control of what happens with your stuff, right? If you don't have a will, if you don't have anything in place, state law determines where your stuff goes. And so that doesn't always align with your preferences. If you're not married, if you've got minor children, right? If you've got kids from different marriages, having a will to direct where things go and who's in charge is critical. And small estates benefit from planning as well, right? Because one of our main goals with planning is to streamline the estate distribution and administration process.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning can often be a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited for today's topic, as always. Today's topic is estate planning myths debunked. The simple estate misconception. Because there's a lot of myths out there that surround estate planning, and knowing what is right and wrong, or myth or truth, is critical. So on today's show, we're talking about estate planning myths debunked, the simple estate misconception. So let's get to it. When the topic of estate planning comes up in conversation, more often than not, the discussion devolves into myths and half-truths. If we're honest with ourselves. My uncle's estate didn't have to go through probate. My friend's brother didn't have a will, and his estate worked out just fine. I can just tell my family what I want to have happen, it'll be fine. I don't need to worry about it after that. While it's a good idea to discuss estate planning, not knowing what is true and what's a myth is not a good thing, right? And can lead to unintended consequences. And we talk about those a lot here on Legacy Talk, those unintended consequences, which is one of the reasons why we're doing this, is to prevent those unintended consequences from becoming consequences. So on today, we're on a mission to debunking estate planning myths that, if followed, could negatively affect and impact an estate. A lot of what we're talking about today is something that we've talked about more in depth, possibly on other episodes of Legacy Talk, but I thought it would be helpful to sort of have an episode where we're putting a lot of different things in one episode that are pretty concise and short little blips about certain myths that there are, and have them all in one 30-minute package. So let's get to it. Myth number one that we're talking about. I don't need an estate plan because my estate is small. So truth, the size of your estate doesn't matter. Having an estate plan is critical regardless of the size of your estate because it ensures that your assets are distributed according to your wishes, and it ensures that you're in control of what happens with your stuff, right? If you don't have a will, if you don't have anything in place, state law determines where your stuff goes. And so that doesn't always align with your preferences. If you're not married, if you've got minor children, right? If you've got kids from different marriages, having a will to direct where things go and who's in charge is critical. And small estates benefit from planning as well, right? Because one of our main goals with planning is to streamline the estate distribution and administration process. And not having a will or not having an estate plan in place, even if it's a small estate, can still lead to a lengthy process. And so in order to make sure your stuff goes where you want it to go, who's in charge, simplify the process, having a will or estate plan in place, even as a small estate, is critical. And then that doesn't even include things like durable power of attorney, healthcare directives that are for when you're alive and don't have anything to do with how much money you have. Myth number 2, a will is all I need. That was our segue. A will is all I need. The reality is, a will's great, but a will only deals with what happens when you die. It specifies distribution of assets after your death. A comprehensive estate plan includes a durable power of attorney, like I mentioned, which is for financial decisions and medical decisions. A healthcare directive, which talks about what happens if you are not able to make decisions at all, and if you are in a permanent vegetative state or an irreversible coma, and doctors have talked about taking you off life support in those situations. What do you want to have happen if there's no chance of recovery? Do you want to stay on life support or not? And another thing that is a benefit oftentimes with an estate plan is having a trust, which can manage assets during your lifetime and after death for beneficiaries over a period of time, right? And so having the will is important. Having the durable power of attorney for finance and healthcare is critical during your lifetime. Having an advance directive or healthcare directive that says what you want to have happen if you're in a permanent vegetative state and not coming back is important. So just a will doesn't really accomplish your goal of making sure that you've got control of your decisions in a state during your lifetime and thereafter. Myth number 3, joint ownership will avoid probate. The reality is there are limitations to joint ownership. Okay. It's true that joint ownership of real estate or other assets like bank accounts can avoid probate. Okay. It does bypass probate for certain assets like real estate or a bank account if it's a joint account, but it doesn't address broader estate planning needs. It can bypass heirs that you may have wanted to have part of your estate, which can create conflicts. There's another thing that nobody ever thinks about when they're saying, well, I'm going to put my kid on my house so that they don't have to go through probate, which doesn't work, by the way, just putting your kid on, because most of the time when we do a deed, when a deed is done for a piece of real estate, not a deed like I'm doing something. When a deed for a piece of real estate is done, it's typically vested as tenants in common, which doesn't have survivorship rights. So just putting your kid on your house or your beneficiary on your house without joint tenants with the right of survivorship will not avoid probate, and it will not transfer that house to that beneficiary without probate. But the issue is, whether it's a joint tenant with right of survivorship or a tenant in common, is that you have liability issues for the joint owner. So if you say, well, I'm going to put my kid on this house or my beneficiary on this house with me so that they don't have to go through probate later, you're subject to all that person's liabilities and credit issues and judgments. So if that kid goes through a divorce or goes through a bad accident, through a lawsuit, your house is part of the potential asset that can be taken. It also doesn't plan for incapacity. It doesn't have any comprehensive distribution scheme. So if you've got more than one kid, or if you've got people that you want to protect, or the person that you're giving the house to shouldn't probably have the house in their own name, it doesn't work. Myth number 4, estate planning is only for the wealthy. The reality is that estate planning is for everyone. Estate planning involves more than just money, as we've talked about. It talks about incapacity, what happens if you can't make a decision. It talks about what happens with your minor children. It appoints guardians for your minor children, and it specifies wishes for your medical care. So all of those things provide peace of mind to ensure personal, financial, and healthcare wishes are respected. Right? Most of my clients that I deal with are not what we would consider wealthy, right? Most people that come in to see me with estate plans are just regular people, right? They've got regular jobs, they've got a house, they've got a 401k like people have. You know, most of them aren't multimillionaires. There's some, right? But most of them aren't. And everybody needs an estate plan. Even if you don't have any assets, but you have a minor child, you need an estate plan because you need to designate where that child goes as a guardian. You also need to have somebody take control of their money for them until they're an adult, right? Through a trust typically. And so all of that stuff is part of an estate plan. So if you have minor kids, even if you don't have any money or even any assets, you need to have your estate plan done. Myth number 5, I can DIY my estate plan. We've had a whole episode on this, and there's a lot of programs out there, websites where you can do a DIY estate plan, but the problem is laws change from state to state, and most of those services don't have state-specific laws. Online templates also don't always address specific issues that you might have, or even ask you about them, or even tell you that you should think about them, right? The professional estate planner ensures that the documents that you draft are legally sound, they're executed properly, and they reflect what the laws say. Also, they reflect what you want them to say, right? We get into the nuance of what you want to have happen, whereas an online interview or a template that you get at Office Depot or whatever won't have that. And so having an estate planning professional help with their estate plan prevents unintended consequences, which could be costly mistakes in the end. Number 6, my family knows my wishes, so I don't need a plan. The reality is verbal wishes are not enough. Verbal agreements or statements or "this is what I want to have happen, kids," often lead to disputes and are not legally binding. Formalizing wishes in legal documents ensures that those wishes will be honored. So they also provide clarity, we'll get into this, and prevent conflicts and disputes later. Sometimes I get people coming in that say they have multiple kids. I'm going to give everything to the oldest kid and let's let them distribute it. They'll do it right. They'll be fair. And I tell people, well, how do you want to have your estate distributed? Well, I'd like all the kids to get an equal share, but I want that person to do it. The misunderstanding there is you can name an executor, right, that's going to be in charge of distributing. That doesn't mean you have to give that executor everything to distribute. And so there's problems where you just say, well, I'm giving everything to Johnny, and I'm going to tell him on the side, say, hey, Johnny, I'm giving it to you, but I don't mean for you to keep all this. I think you should give some to Sally and Bobby and Joey, right? And so these verbal agreements don't work. And you can't bring them in later. They're not evidence either in trying to prove them. So put things in writing. Estate planning needs to be in writing. Number 7, once my estate is done, I never have to update it. Right. The reality is estate planning sometimes need to be maintained or updated. Okay. Certain life events require you to update your estate plan. Whether you have new kids, get married, get divorced, if you have significant financial changes, if you win the lottery, or you lose all your money, or you've just done really well investing, right? Or your 401k and other investments have put you in a taxable status after 10 to 20 years of work. Those are events that you need to have your estate planning looked at and potentially updated, right? Regular reviews ensure that your estate is up to date with your wishes, as well as up to the laws and the tax laws in particular. And it adapts to changes in family dynamics, assets, and the like, right? And so I always say 2 to 5 years you should look at it, even if nothing changes, or if you don't think anything changes, look at it within 2 to 5 years. I'm not sure how many times, hundreds of times, I've had people come in with old wills that they did when their kids were 5 and now their kids are 30 or 40. And Bob next door is the guardian and their brother, who's now dead, is the trustee and the executor. So look at your estate planning, update it regularly. Myth number 8, trusts are only for the rich. The reality is trusts are a versatile estate planning vehicle that offer benefits to estates of all sizes. They provide privacy, they avoid probate, they manage assets for beneficiaries that need assistance like minors or people with special needs, and they help with tax planning. They make it a lot easier on the tax planning side. I almost always do trusts for tax planning cases, and they ensure the controlled distribution of assets. Trust is a great thing because it can not only, it avoids probate, because the assets in the trust are already titled in the trust, and the trust has authority granting provisions that say, trustee, you can do whatever you need to do with regard to this trust according to the terms of the trust, so you don't have to go through probate, okay? Which provides privacy because it's not a public record. Probate, which is the court proceeding to administer an estate, has to go through court and is all public record, whereas a trust doesn't have to do that. It's not public. But with a trust, you can distribute the way you want to. You can provide for those special needs kids or beneficiaries that might not want to get a bunch of assets and get kicked off of Medicaid or Social Security disability. If you have minor children, their assets need to be in a trust because they can't have assets until they're an adult. So trusts are good and versatile and for everybody, really. Myth number 9. We've done a full episode on this one. I'm too young to need an estate plan. The reality is to plan for the unexpected, right? Unexpected events happen at any age. And an estate plan ensures that your wishes are known and are legally enforceable. They provide protection for loved ones and prevent legal challenges or financial challenges later. I've got a lot of parents who come in because their kids have passed, and maybe their kids are in their 20s, and they don't know where to start. They don't know where their kids' assets are. At that point, oftentimes the kids are independent, but they, living maybe in a different place. I've got that happen a lot of times. And so knowing that stuff and having the estate plan in place makes it much better than having to sort of figure things out and deal with probate, intestate probate, and all that stuff. So even if you're young or if you have young children, if you're a person that has children that are adults that are maybe, I don't think I need an estate plan age, talk to them, because it's a good idea. It protects the parents and it protects them. And the things like durable power of attorney and healthcare directive should have had by everybody, really. I think that everybody that has an 18-year-old kid, that 18-year-old kid should have a power of attorney, because you can't talk to the doctors when they're 18, right? Or you can't talk to their bank account if they're 18. And so you have to have an estate plan. It doesn't matter how old you are. Myth number 10. Comes up a lot. Estate planning is too expensive. So the reality is cost versus value analysis, right? The upfront cost of creating an estate plan is almost always less than the costs associated with administering the estate through probate, through paying taxes, and other legal fees caused because you don't have an estate plan. Proper planning saves money in the long run. In addition, it ensures that your wishes are honored, as we've talked about, and it reduces stress and minimizes taxes and administrative costs. So probate, in my practice, it's almost always cheaper to do a revocable trust plan than to do a probate. And with a revocable trust plan, you're not going to go through probate. And doing a simple will, saying, well, I'm going to do a will plan, which is fine. That will's going through probate almost always. And so they're probably going to pay more in the long run than a trust plan that doesn't go through probate. And so that part of it is easy to see the math, right? The other part is, well, am I going to have a taxable estate? And in Washington, we have a very low tax threshold. It's $2.193 million per person that can pass without paying estate tax. And so if you do this tax planning that might cost a little bit more money than a simple will, it's going to be a small fraction of what the estate tax would be if you had to pay it. And so there's a lot of cost-benefit analysis there. You're getting the value of having the peace of mind to not have to deal with your estate taxes, not having to deal with probate, not having to have this uncertainty as to where your stuff goes, not putting your people through, basically a terrible process of going through a probate without knowing what's going on, without knowing what your assets are, without having a will to guide them or a trust to guide them, having to go through an intestate process, posting bond and things like that in a probate estate. It just makes it so much easier to have these things dialed in. So just for the time savings and the peace of mind, it's worth, yeah. So now that brings us to our story time for this episode. The story this time is about a transfer on death deed, which we didn't talk about today, but it's sort of like joint ownership. A transfer on death deed is a deed that you can make that says, when I die, give this house to so-and-so, my beneficiary. Okay. And so I had a client come in, and there was a son whose mother was needing long-term care, and they said, well, I want to have a transfer on death deed so that I can sell the house, not have to go through probate when mom dies. And the problem with that is the transfer on death deed was going to bypass other beneficiaries. And the intent was that he would distribute the proceeds from the house when his mom died, due to his own goodwill for his siblings. Problem with that is he wouldn't have to, right? He wouldn't have to legally do that. And so that would potentially lead to disputes among heirs. It would lead to probably allegations of undue influence or having mom sign these things under duress and potential personal liability for him if it turned out that those things were true. So the solution to that problem would have been to have mom do a will or trust that says, when I die, give the house to my kids in this percentages, right? And have this oldest son or whoever the son was be in charge, right? So that the house will be distributed according to their wishes. And have a durable power of attorney in place so that if they had to sell the house for long-term care before mom died, the son with power of attorney or beneficiary with power of attorney would be able to sell the house and use those funds for long-term care. Having just a simple document that says, give the house to Bobby when I die, doesn't always accomplish the goal. It might seem like it does, but it causes more problems than you're anticipating. Disputes among the heirs, personal liability, threats and allegations of being unduly influencing your parent or the person making the deed. So it's not worth doing that. So that's the story. And that brings us to our In the News Something Good segment. And as I record this, the Olympics are going on. So this will come out in a couple weeks and the Olympics will have just ended probably. But from CNBC, there's this article. And this is something that's been in the news, so you may have heard about it. But from CNBC, forget Simone Biles. The American stealing the show at the Paris Olympics is Flavor Flav. The 65-year-old performer has been a fixture at the 2024 Games thanks to his partnership with USA Water Polo. The Public Enemy rapper has embraced his new role as official hype man of the women's water polo team, appearing poolside at the team's matches wearing a water polo cap and Team USA branded waterproof clock necklace, which is his trademark. Under the terms of the sponsorship deal, which was announced earlier this month, Flavor Flav will make multiple appearances at USA water polo events each year, as well as lend his social media presence to the team to help amplify the sport's reach and engage new audiences. This is one of the biggest things I feel that I could have ever done in my life outside of other accomplishments that I've made in music, he said. By sponsoring a water polo team and helping these girls out, this is bigger than me winning a Grammy. The rapper first connected with the team in May after athlete Maggie Steffens posted on Instagram about the lengths to which she and her teammates have gone to get to the Olympics and make their dreams a reality in a sport that's not as widely popular as others. Many of my teammates aren't just champions, but also teachers, business owners, coaches, physical assistants, physicians, and more. Some may not know this, but most Olympians need a second or third job to support chasing the dream, including her. And most teams rely on sponsors for travel, accommodations, nutritional support, rent, lodging, and simply affording to live. In a comment on the post, Flava Flav committed his support to the team that has won gold for the last 3 Olympics. He said, "As a girl dad and supporter of all women's sports, I'm a personally sponsor you, my girl. Whatever you need," he commented. "My manager is in touch with your agent, and I'm going to use my relationships and resources to help all y'all even more." That's a Flava Flav promise, he says. He's a funny guy. Flava Flav is now working with the team for 5 years and giving an undisclosed amount of financial support with unlimited hype. So that's a pretty cool story. Someone that sees a need, that has means, and is making an impact on an underrepresented and less popular, potentially, sport like women's water polo, which is a really fun sport, and it's really hard. Men's water polo as well. Very difficult sport. Anyway, that's the end of our episode. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.